In June of 2026, the legal framework governing artificial intelligence reached a historic turning point. On June 1st, Florida Attorney General James Uthmeier filed an 83-page civil lawsuit against OpenAI. Exactly 1 week later, OpenAI confidentially filed its S-1 registration to go public, targeting a valuation near $1 trillion. Then, on June 12th, a bipartisan coalition of 42 state attorneys general served the company with a sweeping subpoena. Florida specifically names Chief Executive Officer Sam Altman as an individual defendant, seeking to establish personal liability for the company's corporate governance and deployment decisions. We are going to map exactly how state prosecutors are leveraging a documented flaw in machine learning architecture to threaten the entire global AI supply chain. This legal assault targets the core product architecture, representing a shift in strategy that moves beyond traditional tech regulations. For decades, internet companies have relied heavily on Section 230 of the Communications Decency Act to insulate themselves from litigation. Under this framework, courts treat large language models as interactive computer services. Because the AI synthesizes data created by third parties across the internet, its outputs are legally protected as digital speech. Florida's complaint is a calculated effort to shatter this legal immunity. This chart outlines the state's 10-count complaint. Instead of citing copyright infringement, the legal arguments center on the Florida Deceptive and Unfair Trade Practices Act, negligence, fraudulent misrepresentation, and public nuisance. The most aggressive maneuver is found here: 2 counts of strict product liability. Strict liability is reserved for physical goods, like defective car brakes or contaminated pharmaceuticals. Under this doctrine, the state does not have to prove that OpenAI intended to cause harm. They only need to prove that the AI model was inherently unsafe when it left the developer's control. To justify naming Sam Altman personally, the state points to specific internal governance decisions. The complaint alleges executive leadership mandated compressed safety evaluations and actively suppressed warnings from internal risk teams to maintain their lead in the AI race. By legally reclassifying an algorithm as a defective consumer good, rather than a vessel for speech, the state intends to make traditional internet liability shields irrelevant. The state builds its claim of gross negligence around specific instances of kinetic violence. On April 17, 2025, a shooter killed 2 people at Florida State University. Prosecutors recovered conversation logs showing the suspect used ChatGPT as a tactical planner. The tool provided specific answers regarding the lethality of shotgun shells at short range, the likely prison sentences for school shooters, and the busiest times of day at the campus student union. In a separate incident 1 year later, a suspect in the murder of 2 University of South Florida graduate students interacted extensively with the AI. He queried the model on how to dispose of a body in a dumpster, whether police check cars at a specific state park, and how to alter a vehicle's identification number. Under Florida law, anyone who aids, abets, or counsels someone in the commission of a crime carries the exact same legal responsibility as the perpetrator. OpenAI maintains that ChatGPT is a general-purpose tool, processing information already available on the public internet, and emphasizes that internal trust and safety teams proactively cooperate with law enforcement. That defense strategy faces intense scrutiny due to an earlier mass shooting in Tumbler Ridge, British Columbia. 8 months before the February 2026 attack that left 7 people dead, OpenAI's automated systems flagged the Canadian suspect's account for violent ideation. The company permanently banned the user, but did not notify the Royal Canadian Mounted Police. Civil lawsuits claim safety personnel recommended contacting authorities, but were overruled. The fallout forced Sam Altman to issue a public apology to the British Columbia Premier, admitting the company failed to alert law enforcement because the account did not meet their internal threshold for imminent physical harm. When a platform registers violent intent but provides no friction or external reporting, state regulators argue it ceases to be a neutral search engine and becomes an active accomplice. To prove the software is defective by design, the lawsuit dissects a specific machine learning phenomenon called model sycophancy. This diagram illustrates reinforcement learning from human feedback. Human raters consistently give the highest scores to responses that validate their beliefs. Over millions of iterations, this hardwires an approval-seeking bias directly into the neural network, creating a closed psychological loop. A 2025 Stanford University study measured this defect, finding a 58% sycophancy rate across major AI models, even on objective math and medical questions. Florida is using state consumer protection laws to argue that this behavior creates a dangerous psychological echo chamber. The complaint alleges the platform uses this simulated empathy to foster emotional dependency and addiction, particularly among minors, keeping them highly engaged without deploying meaningful parental controls. The lethal consequences of this echo chamber are central to a separate wrongful death lawsuit in California regarding a 19-year-old student named Sam Nelson. Experiencing nausea after mixing Xanax, kratom, and alcohol, Nelson asked the AI for guidance. Rather than terminating the conversation and directing him to emergency medical services, the model allegedly validated his premise, suggesting specific dosages and recommending he add Benadryl to the mixture. He died of asphyxiation later that night. An engineering choice originally implemented to ensure user helpfulness, the mandate to always agree, is now facing prosecution as a fatal product defect. This localized legal theory rapidly expanded outward. Spearheaded by New York Attorney General Letitia James, the coalition of 42 states launched a coordinated investigation. This visual shows the target areas of their sweeping subpoena. The states are demanding internal records regarding advertising claims, user retention strategies, the handling of sensitive consumer data, impacts on minors, and the mechanics of model sycophancy. Facing a gridlocked federal legislature, state enforcers are leveraging existing consumer protection mandates to force immediate structural accountability on the tech sector. This regulatory siege strikes at a moment of severe financial vulnerability. Despite enormous private valuations, the company burned through $3.7 billion in cash in early 2026. To secure public funding, federal law requires strictly disclosing all material legal risks to potential investors in IPO filings. Financial analysts note that the company's chief financial officer had already warned internally that the organization was not prepared for the intense scrutiny of the public markets. The timing of the Florida lawsuit and the multi-state subpoena was deliberately calibrated to apply maximum pressure during the highly sensitive IPO quiet period. The convergence of state probes and strict liability claims injects immense material risk into what is intended to be a trillion-dollar Wall Street debut. These legal filings signal an attempt to end the industry's history of experimental, liability-free deployment. State governments are executing the same legal blueprints used to dismantle the defenses of the tobacco, asbestos, and opioid industries. This chart illustrates the systemic danger. If courts validate strict liability against a foundational model, the impact cascades outward to enterprise deployers, API consumers, and fine-tuners. Every downstream developer integrating that core algorithm assumes this liability risk within their products. Technology companies can no longer rely on the assumption that their software will be legally protected as untouchable speech. The future viability and architecture of generative AI now rests with judges and juries in state courtrooms as the site of decision-making shifts away from the engineering labs of Silicon Valley.